I don't see Ms. Romer or Miss Martin. So we can move on to Robert Ramey. Is Mr. Ramey in jail?
No, sir, he's out on bond.
Oh, okay. Mr. Ramey, can you hear me, sir? Have all the plea documents been submitted on Mr. Ramey?
I believe so, Your Honor.
Let me make sure.
Your Honor, did you say that Mr. Ramey was here, or I can't see if he's a participant or not?
I see that he was trying to connect to audio.
Okay.
There he is.
I'm here.
A little bit.
Good morning, Robert.
Good morning. Good morning.
Okay.
And Gmail either. You won't let me onto the internet.
Okay. We will go on the record in cause numbers D40408 and D40410, both Style State versus Robert Eugene Ramey. I have counsel present for both sides, defendants present. And Mr. Ramey, is that your full and complete name?
Yes, sir.
Mr. Ramey, you're here with your attorney, Mr. Keithley, and it's my understanding that you're wishing to enter a plea of guilty to the offenses of possession of controlled substance, penalty group 1, less than a gram, and then possession of controlled substance, penalty group 1, over 4, less than 200 grams. Is that correct?
Yes, sir.
Okay. And do you understand, sir, what you're pleading guilty to?
Yes, sir.
All right. Mr. Keithley, in both cases, do you wish to waive readings of the indictment?
Yes, Your Honor.
Record can so reflect. Mr. Ramey, in both cases, I do have documents that appear to have your signature on them. They are written waivers, written plea admonishments, a waiver of your right of appeal, a judicial confession, and evidence discovery log. Did you sign these documents, sir?
Yes, sir.
Did you understand everything you signed?
Yes, sir.
Do you understand, sir, that you have a right to have a jury trial in both cases and you're waiving that right?
Yes, sir.
Do you understand, sir? Well, let me ask you this, sir. Are you a citizen of the United States?
Yes, sir.
And the possession over 400, less than 200, sir, is a second-degree felony, punishable anywhere from 2 to 20 years in the Texas Department of Criminal Justice Institutional Division, and a fine not to exceed $10,000. You understand the range?
Yes, sir.
The other case is a state jail felony. It carries a range of punishment anywhere from 180 days up to 2 years in state jail, and a fine not to exceed $10,000. You understand the range in that case?
Yes, sir.
It's the court's understanding, sir, that you've entered into plea agreements with the state through your attorney. Is that correct?
Yes, sir.
Now, the court will not agree to be bound by the plea agreement. The plea agreements that you've entered into However, the court follows the plea agreements. It does cut off your right of appeal except by permission of the court. Do you understand that?
Yes.
Are you entering your pleas of guilty freely and voluntarily?
Yes, sir.
Do you understand, sir, the consequences of your pleas of guilty?
Yes, sir.
Your attorney's Mr. Keithley. Are you satisfied with his representation?
Yes, sir.
Mr. Keithley, your client appears sane and mentally competent. Anything he said or done that would cause you to believe otherwise?
No, Your Honor, I've had conversation with my client and I believe that he is sane and sane and mentally competent.
All right, the court at this time will find that Mr. Ramey is sane and mentally competent. Court will find that he's freely and voluntarily entered his pleas of guilty, that he understands the consequences of his pleas of guilty. The court will accept those pleas of guilty and either find the defendant guilty of the offenses alleged in the indictments or consider deferring findings of guilt. I have in front of me states one in each case, judicial confession signed by the defendant. State seeking to have those exhibits admitted.
Yes, Your Honor.
No objection to states one in each case, Your Honor.
They're admitted. Anything further from either side?
No, Your Honor.
Defense rests with regards to the guilt innocence phase.
Okay. I'll take a recommendation then in the the state jail felony case first.
I believe they're both going to be the same, Your Honor. It's going to
Okay.
be deferred adjudication on both of them for 8 years. On 40410, that is where the $500 fine and the $290 court cost will be. On both of them, he is to combine. He is to complete ADAC, VOEP, 250 hours of community service, just one,
Okay.
set one time. Reimburse the county for court-appointed attorney's fees, reimbursement of $180 payable to the Texas DPS Austin Crime Laboratory. And in regards to the weapon, that one is on D40408. We have made an agreement with the defendant, and if the court allows, the weapon in question actually belonged to his mother. And as long as his mother will come to Texas and she is eligible to own a gun, then the gun can be released to her, but otherwise he would forfeit that weapon.
Okay. And Mr. Keithley, is that you and your client's understanding?
Yes, Your Honor. And I guess for clarification, with regards to the deferred adjudicated probated sentence on the state jail, if it is reflecting 8 years, I don't know if the court has the ability to do that, but if you could just incorporate and let it be encapsulated in a 5-year deferred term with regards to state jail maximum term of punishment. I don't know if that's judgment says that or not.
I'm not sure. I'm sorry.
Ultimately, it's an 8-year deferred sentence, Your Honor, that as far as the length, yes, sir.
But I don't think it could be more than 5 though on the state jail.
Right. It's academic, but I guess just for the amount of clarification for the judgment, just.
Yeah, it's better to
Correct.
get it right at this point. So I will, if it says 8 on it, I will strike through that language, that number, and put 5.
Thank you,
Thank
Your
you,
Honor.
Your Honor.
Okay.
Your Honor, that is the correct resuscitation of the plea agreement. May I call my client briefly on some housekeeping matters?
Should. Yes, sure. Not should. I'm writing the word should, and I said that, but sir, do you want to raise your right hand? Do you swear or affirm the testimony will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right.
You are Robert Ramey, is that right? Sir, you are Robert Ramey, is that correct?
Yes, sir.
Okay.
Sorry.
Robert, you and I have had a chance to talk about this case at some length, have we not?
Yes, sir.
Talked about the discovery, there's discs involved, a bunch of stuff. We talked about what would be our trial strategy should we have to go to trial, correct?
Yes, sir.
About the state's burden of proof and their requirement to prove actual possession and so forth. And we had discussions about possible strategies. Is that fair to say?
Yes, sir.
Also, Robert, we talked about a concept known as a motion to suppress, something about the exclusionary rule. and actually filed a motion to suppress, and we're set to have a hearing on a motion to suppress. In fact, this afternoon, we talked about our strategies, and I told you about my concerns that of the possible deficiencies in the government's warrant. Did we have the discussions on that?
Yes, sir.
Irrespective of those strategies and discussions, did we decide, and you authorized me to go ahead and enter into plea negotiations for a deferred adjudication plea and resolve the cases, not by going to trial, not by going forward on the motion to suppress, but by resolving it as the plea agreement as we've enumerated to the court today. Is that correct?
Yes, sir.
All right. Now, we also had a discussion about the pros and cons of deferred adjudication, did we not? About the good side and the bad side.
Yes, sir.
The good side, obviously, being that if you can live this out, you're not felony convicted. You don't face any of the consequences of a convicted felon, and you can petition the court for an order of non-disclosure at some point if the conditions arise. So that we talked about those good points, right?
Yes, sir.
The bad side, though, we talked about was that if you screw up on probation, if you do something that offends the probation department or violates the terms and conditions of your probation, you may very well be looking at the full range of punishment in this case, and that would be fairly high. It's more high than a normal probation. We talked about that.
Yes, sir.
Irrespective of those discussions, is your desire to have Judge Largmacino go ahead and follow the plea agreement and give you deferred adjudication in this case?
Yes, sir.
With respect to the weapon that Ms. Schumer talked about, for the record, that is specifically a Springfield Armory P9 9mm, correct?
Yes, sir.
That had been your father's. I mean, it's been in the family. You want to maintain it for sentimental reasons, but we've arranged that it is to be returned to your mother, Ms. Diane Lewis, maiden name Duxbury, who is planning to travel to Texas to retrieve that weapon and only have it in her possession. Is that correct?
Yes, sir.
Okay. Is there anything that I haven't answered or to your satisfaction, or are we all good to go?
We're all good to go.
I'll pass the witness.
Any questions of this witness from the state?
No questions, Your Honor.
All right. Mr. Ramey, you understand you have a right to petition the court in the future for an order of non-disclosure.
Yes, sir.
All right, sir, based on the evidence the court has admitted, the court will find in both these cases the evidence substantiates finding you guilty of the offenses alleged in each indictment. It'll be the judgment of the court in both cases that suspension of or the court will defer findings of guilt in both cases. In the possession under a gram, that'll be for a period of 5 years. In the other case, for a period of 8 years. During this period of time, sir, you are ordered to comply with all terms and conditions of probation. Do you understand that?
Yes, sir.
You understand? Do you read and write, sir, the English language?
Yes, sir.
Okay, make sure, sir, that you read through that order. If you have any questions, you need to ask your attorney or the probation officer that you're reporting to. Do you live here in Navarre County, sir?
Yes, sir.
All right, you'll be reporting to an officer. I see that you're out on bail right now, so you'll need to report today or whatever day the probation department sets up with you to report, okay, for an intake. You understand that?
Yes, sir.
Mr. Ramey, you'll need to come to the courthouse today and get your prints on the judgments that I will be signing here momentarily, okay?
Yes, sir.
All right. Do you have any questions or concerns, sir?
Not that I can think of, sir.
All right. Well, if you think of anything, you need to ask Mr. Keithley or probation. In both cases, sir, you've waived your right of appeal. That concludes both these hearings. But don't leave. I think Ms. Redden's going to give you some directions.
Good luck, Robert.
Thank you.
Let me, I'll be right back. I got to run to my office for one thing.
Mr. Ramey, I'm Deborah with adult probation. So
Yes,
when
ma'am.
you report to the courthouse today, once you leave the courthouse, do you know where our probation department is located?
Yes, ma'am.
Okay. You'll need to report to probation. At what time do you think you're going to go to the courthouse?
As soon as I can get a vehicle, I'm going to borrow one from my neighbor. So
Okay.
it should be momentarily.
Okay, so you'll need to report to probation by 11 o'clock this morning. Do you think
Yes,
that's
ma'am.
doable?
I'm going to try. Yes, ma'am.
Okay. Do you have pen and paper?
Yes, ma'am.
I want you to write my number down.
Okay.
903-654-3066.
3066.
That's correct. 903-654-3066. Give me a call when you are about to head this way. We're closed from noon till 1 for lunch.
Okay.
Thank you, sir.
You're welcome, ma'am.
Mr. Ronnie Shannon? Okay.
Yes, sir.
How you doing, sir?
All right, I reckon.
All right, let me,
Morning, Ronnie.
I just now got some of this stuff in the queue, so I need to review it very quickly. Can y'all tell me on 40892, I see both second and third degree. Is that because of an enhancement?
Yes, Your Honor.
Okay. There's some good things about e-file and there's some bad things. One of which is sometimes you can't see everything that you need to see just on what's in front of you, but
I certainly agree with that. I like to spread stuff out.
Okay. Leslie, you ready?
Yes, thank you.
Okay, we'll go on the record in cause numbers D40890 and D40892, both style state versus Ronnie Shannon. And I have counsel for both sides present, defendants present. Mr. Shannon, is that your full and complete name?
Yes, sir, it is.
And Mr. Shannon, this is the court's understanding that you're wishing to enter pleas of guilty in both of these cases.
Yes, Your Honor, it is.
And the one is the assault with intent to recklessly causing breath or impeding circulation of a family member. The other one is assault on a family member with a previous conviction. Is that correct?
Yes, sir.
And it's the court's understanding you're wishing to enter plea to guilty, and you're in a plea of true and cause number D40890 to the enhancement paragraph. Is that correct?
Yes, sir, it is.
And in the enhancement in the other case. Is that correct?
Yes, sir, it is.
All right. I don't think Mr. Shannon has been arraigned or in this case, if I'm not mistaken, because looks like there was, well,
I believe you are correct, Your Honor.
okay.
There was a
So,
re-indictment.
yeah. Mr. Keithley, do you wish to waive arraignment in both of these cases and 10 days?
Well, yes, sir. Waive arraignment so I guess procedure at this stage, to let the court know that we're planning on entering a plea of guilty on both cases, but we would waive 10 days of preparation.
Okay, record can so reflect. So Mr. Shannon, I do have documents I've just signed previously prior to this hearing that appear to have your signature on them. They're written waivers, written plea admonishments, a waiver of your right of appeal, judicial confessions, and evidence discovery logs. Did you sign these documents?
Yes, sir, I did.
Did you have an opportunity, sir, to discuss these documents with your attorney?
Yes, sir, I did.
And did you understand everything you signed, sir?
Yes, sir, I did.
You understand that you have a right in both these cases to have jury trials and you're waiving that right?
Yes, sir, I do.
You understand you have a right to have the same jury assess punishment should you have been found guilty?
Yes, sir, I do.
Are you a citizen of the United States, sir?
Yes, sir, I am.
Okay, make sure I've got this correct. The D40890, sir, is a second-degree felony, punishable anywhere from 2 to 20 years in the Texas Department of Criminal Justice Institutional Division, and a fine not to exceed $10,000. You understand the range?
Yes, sir, I do.
The other case, sir, is that a third-degree felony?
Yes, Your Honor. I believe
Yes,
so.
sir. Yes, sir.
Third-degree felony, punishable anywhere from 2 to 10 years in the Texas Department of Criminal Justice Institutional Division, and again, a fine not to exceed $10,000. You understand the range there?
Yes, sir, I do.
It's the court's understanding in both cases, sir, you have entered into plea agreements with the state through your attorney.
Yes, sir.
And the court will not agree to be bound by the plea agreement. However, the court follows the plea agreement, cuts off your right of appeal except by permission of the court. You understand that?
Yes, sir.
Are you entering your pleas of guilty freely and voluntarily?
Yes, sir, I am.
And do you understand, sir, the consequences of your pleas of guilty?
Yes, sir, I do.
Your attorneys, Mr. Keithley, are you satisfied with his representation?
Yes, sir, I am.
Okay, and Mr. Keithley, your client appears sane and mentally competent. Is there anything your client has said or done that would cause you to believe otherwise?
No, sir. I believe he's sane and mentally competent.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his pleas of guilty. He's freely and voluntarily entered his plea of true. The court will accept those pleas of guilty and true and find the defendant guilty should the evidence prove him guilty. In both cases, I have states: one, judicial confessions, signed by the defendant, state seeking to have those exhibits admitted.
Yes, Your Honor.
No objection.
They're admitted. Anything further from either side?
No, Your Honor.
No, sir.
State have recommendations, and I'll start with, I guess, 890 first. Or it doesn't matter.
Okay. I wouldn't find on the right same numbers. Okay, in D38379. Oh, I'm sorry. I'm looking at the next case. I apologize, Your Honor.
That's fine.
That's why I couldn't find it.
Well,
Okay. In D40890, the term is 7 years TDCJ, $1,500 fine, no contact with Brandy Shannon, and credit for 285 days. And that's going to be the same in both cases, Your Honor.
credit for how many? 285?
285 days, Your Honor.
And the same fine amount on the other case?
Yes, Your Honor.
Which case has court costs?
I don't believe they typed it on either one of them. So let's see.
What if I just add it to 90?
That will work, Your Honor.
Okay. All right. And Mr. Keithley, is that you and your client's understanding?
Yes, sir.
Yes, sir, it is.
All right. Based on the evidence, the court will find the defendant guilty of the offenses alleged in each indictment. The court will find the enhancement paragraph to be true. The court, finding the defendant guilty of both offenses, sentences him to 7 years in the Texas Department of Criminal Justice Institutional Division. Fines of $1,500 are imposed in each case. Court costs are assessed in the 890 case. Any reason why a sentence should not be pronounced?
No, sir.
All right, Mr. Shannon, you are sentenced to 7 years in the Texas Department of Criminal Justice Institutional Division. You'll be remanded to the custody of sheriff, who will transport you to the appropriate facility to begin serving out the sentence. This sentence begins today. You are given credit. Well, these sentences begin today. You are given credit on both these sentences of 285 days, and any day thereafter you're awaiting transport to TDC. These sentences run concurrently. Do you have any other sentences or any other cases pending here in Navarro County?
Yes, sir. I got a misdemeanor assault case.
Okay. All right. Well, I'll let you take care of that with the county judge and through your attorney. Okay.
Yes, sir.
All right, sir. In both these cases, you've waived your rights of appeal, and that concludes both these hearings. The bailiff will come over here shortly and get your prints and on the judgment and on the docket sheets. Okay.
Yes, sir.
All right, sir. Wish you all the best.
Thank you, sir.
Good luck, Ronnie.
Thank you.
Hey, Robert.
Yeah, that's fine. I need to go into e-file to make sure I get everything I just did. Well, which one did I say I was going to put court costs on? Oh, that was 890.
90, yes.
I don't see 90. I may have already signed it. I guess Joshua Thomas. Mr. Thomas,
Yes, sir.
how you doing, sir?
I'm doing good.
All right, I'll go ahead and take up the new case first and then get to the revocation. And, okay. So strange to look in a file and not see anything written on it, but that's only because we're not having these court appearances, so. All right. I will go on the record in cause number D40809, State versus Joshua Glenn Thomas, and I have State's Counsel present, Defense Counsel is present. Defendant is present. Mr. Thomas, is that your full and complete name?
Yes, sir.
Mr. Thomas, it's the understanding of the court that you're wishing to enter a plea of guilty to the offense of possession of controlled substance, penalty group 1, less than a gram. Is that correct?
Yes, sir.
And sir, do you understand what you're pleading guilty to?
Yes.
All right, Mr. Price, do you wish to waive a reading of the indictment? You're muted, Mr. Price.
All right, sorry about that. Yes, he understands what he's charged with. We'll waive reading of the indictment.
All right, record can so reflect. Mr. Thomas, I have documents that I've signed here a little bit ago that appear to have your signature on them. They are written waivers, written plea admonishments, waiver of your right of appeal, a judicial confession, and an evidence discovery log. Did you sign these documents?
Yes, sir.
Mr. Thomas, did you have an opportunity to speak to your attorney about these documents?
Yes.
And he went over them with you, is that correct?
Yes, sir.
You understand you have a right to have a jury trial and you're waiving that right?
Yes, sir.
You understand also, sir, you have a right to have that same jury assess punishment if you were found guilty.
Yes, sir.
Are you a citizen of the United States, sir?
Yes.
Okay. This is a state jail felony, sir. It carries a range of punishment anywhere from 180 days up to 2 years in state jail and a fine not to exceed $10,000. You understand the range?
Yes.
It's the court's understanding, sir, you've entered into a plea agreement with the state through your attorney. Is that correct?
Yes.
Now, the court will not agree to be bound by the plea agreement. However, if the court follows the plea agreement, it does cut off your right of appeal except by permission of the court. You understand that?
Yes, sir.
Are you entering your plea of guilty freely and voluntarily?
Yes.
And do you understand, sir, the consequences of pleading guilty here this afternoon or this morning?
Yes.
Your attorney is present with you, Mr. Price. Are you satisfied with his representation?
Yes.
And Mr. Price, your client certainly appears to be sane and mentally competent. Anything that your client has said or done that would cause you to believe otherwise?
No, Your Honor.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of guilty, that he understands the consequences of his plea of guilty. The court will accept that plea of guilty and find the defendant guilty should the evidence prove him guilty. I have in front of me states 1, a judicial confession signed by the defendant. State's seeking to have that exhibit admitted.
Yes, Your Honor.
No objection.
They're admitted. Anything further from either side?
No, Your Honor.
No, Your Honor.
All right. State have a recommendation in this case?
Yes, the recommendation is 9 months state jail, $290 court cost, 180-day reimbursed DPS crime lab, court-appointed attorney fees, and 192 days jail time credit.
That's our understanding.
Okay. No fine?
We did not
No,
discuss
Your
it.
Honor.
Okay. All right. Mr. Thomas, based on the evidence, the court will find you guilty of the offense alleged in the indictment. It's the judgment of the court. You're sentenced to 9 months in a state jail facility with court costs and restitution to be assessed. Any reason why a sentence should not be pronounced?
No, Your Honor.
No, Your Honor.
Mr. Thomas, you're sentenced to you're sentenced to 9 months in a state jail facility. You are remanded to the custody of sheriff who will transport you to the appropriate facility, begin serving out the sentence. This sentence begins today. You are given credit on the sentence of 192 days. And any day thereafter you're awaiting transport. This sentence will run concurrently with any other sentence you may receive out of this court. And then finally, the court will make a finding that you are presumptively entitled to receive diligent participation credit if and when that's received by the court. You understand that?
Yes, sir.
In this case, sir, you have waived your right of appeal. That concludes this hearing. I will just tell y'all both, I don't have judgments yet on Mr. Thomas, whether this one I just did and the old one, and the one I'm about to do.
Mine shows the Dana e-filed it yesterday, but I will double check with her and be for sure.
Okay. While you're doing that, I'll go ahead and go to the next one then.
Okay.
Joshua Thomas. I've got both too. 36960. I only see. Oh,
So you just did the 809.
Oh.
So you have 60, so I need to get 50.
okay.
That's what it is.
Oh.
You see the judgment on 40809, Judge?
Let me go back and look.
I'm gonna get Lindy to e-file these unless you tell me otherwise.
Yeah, I don't.
I've got an e-file on that one. Let's see. Also 36960, I see a judgment there. And 36958. E-filed yesterday afternoon. Between 349 and 356.
I'm just not seeing them yet in my. Let's see, can you let Carolyn know, on Ramey, I need to make a change to the judgment to reflect 5 years instead of 7, and then I need to add court costs to Mr. Shannon's case.
Yes, sir.
My gosh. Okay, I have a judgment now for 36958 and 36960.
I think Dana's talking to somebody now.
Okay,
She filed them yesterday.
I see them now.
Okay.
Let me sign 809 first so I can get that out of my queue. I remember signing the plea packets. I just don't remember. Okay. This is like a really bad episode of Law and Order, isn't it?
Without the good music.
Yeah, and the good looking judge.
That's right.
Oh, wow.
I had to say it. Somebody was thinking it. Okay, and I've got Mr. Thomas's, both of Mr. Thomas's files now on his revocations.
Okay.
Now, before we go on the record, are these both going to be, well, one's a state jail and the other one was enhanced to a, I guess,
Third.
To a third.
yeah, okay. And so one was a deferred and one was, okay. All right, we'll go on the record and cause numbers D36958 and 36960, both Style State versus Joshua Glenn Thomas. And again, I have counsel for both sides present, defendants present. Mr. Thomas, is that your full and complete name?
Yes.
And are you the same individual, sir, that was placed on community supervision by this court back in 2016?
Yes.
And one cause number that ends with 960, sir, the court deferred a finding of guilt for a period of 10 years. That was for prohibited substance in a correctional facility. And then in the other case, the court found you guilty, but probated that sentence in the possession of controlled substance case. Do you recall that?
Yes.
Now, in both cases, sir, the court ordered that you comply with terms and conditions of probation. Do you recall that?
Yes.
And since that time, the state has filed motion to revoke and a motion to adjudicate. Do you understand that?
Yes.
And it's the court's understanding your wish to enter a plea is true to the allegations in both motions. Is that correct?
Yes.
And are you doing this freely and voluntarily, sir?
Yes.
Do you understand the consequences of pleading true?
Yes.
All right. And Mr. Price, do you wish to waive readings of both motions?
Yes, he understands what the allegations are and enters his plea of truth.
Record and so reflect. Mr. Thomas, I have documents that appear to have your signature on them. There are written waivers and stipulations on revocation probation. There is a judicial confession and a waiver of your right of appeal. Did you sign these documents?
Yes.
Did you have an opportunity, sir, to discuss these documents with your attorney?
Yes.
Did you understand everything you signed, sir?
Yes.
You understand that you have a right to have contested hearings in these cases, and you're waiving that right.
Yes.
Your attorney's Mr. Price, are you satisfied with his representation in both of these cases? Are you satisfied with your attorney?
Oh, yes.
Okay. And Mr. Price, your client, he certainly appears to be sane, mentally competent. Is there anything that he has said or done that would cause you to believe otherwise?
No, Your Honor.
The court at this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his pleas of true, that he understands the consequences of his pleas of true. The court will accept those pleas of true and take appropriate action based on the evidence. In both cases, I have states one, judicial confession signed by the defendant, state seeking to have those exhibits admitted.
Yes, Your Honor.
No objection.
They're admitted. Anything further from either side?
No, no.
No, Your Honor.
They have recommendations.
Yes, in D 36958, on a finding of true, on the state jail felony, the state's recommendation is 9 months state jail with 284 days credit, with all previous fines, court costs, and restitution that has not been paid. The $500 fine, the $309 court costs, and the $180 restitution.
Okay.
And the court appointed attorney fees.
Okay. And Mr. Price, is that you and your client's understanding?
It is, Your Honor. He is indigent and he's staying in prison for a minute, so we'll ask that you waive that.
Did you say a minute?
Probably.
Yeah, okay. That's what I thought.
I got to learn the lingo.
You've learned it. Okay. Mr. Thomas, based on the evidence that's been admitted in this case, the court will grant the state's motion to revoke your probation. It's the judgment of the court. You're sentenced to 9 months in a state jail facility with any outstanding fines, court costs, fees to be assessed. Any reason why sentence should not be pronounced?
No, Your Honor.
Mr. Thomas, you are sentenced to 9 months in a state jail facility. You're remanded to the custody of sheriff who will transport you to the appropriate facility, begin serving out the sentence. This sentence begins today, sir. You are given credit on the sentence of 284 days. And so I think that satisfies this sentence, but I'll just, out of abundance of caution, I'll make a finding. And this may not be one that's applicable, but I'll make a finding that you are presumptively entitled to receive diligent participation credit if and when that's received by the court. You understand that?
Yes, sir.
Okay. In this case, sir, you've waived your right of appeal as far as 36960 then, and the court will make a finding he is indigent, so attorney's fees are waived. And then in the other case?
And 36960, upon adjudication of guilt, the state is offers 2 years TDCJ, $1,000 fine, $249 court costs, with a credit of 284 days and restitution of the court-appointed attorney fees.
That's our understanding. Same objection to the attorney's fees, Judge.
All right. Sir, based on the evidence, the court will grant the state's motion to adjudicate. This time, the court will find you guilty of the offense alleged in the indictment. It's a judgment of the court, sir. You're sentenced to 2 years in the Texas Department of Criminal Justice Institutional Division. Any reason why sentence should not be pronounced?
No, Your Honor.
Sir, at this time, you are sentenced to 2 years in the Texas Department of Criminal Justice Institutional Division. You're remanded to the custody of sheriff who will transport you to the appropriate facility to begin serving out the sentence. This sentence begins today. You are given credit on the sentence of 284 days. Any day thereafter, you're awaiting transport. It runs concurrently with the other sentences you've received. Attorney's fees are waived. In this case, sir, you've waived your right of appeal. That concludes these 2 hearings. Mr. Thomas, the bailiff will come over here shortly and get your prints on the judgments and on the docket sheet. Do you have any other cases pending, sir?
Yeah.
No.
Yes, and Mr.
Misdemeanor.
Yes, no.
All right, sir, good luck to you.
Hey, I got one question. Do my St. Pete time go with me, or I don't get that? It ain't going.
I don't think that was calculated in, but you've got plenty of back time, man.
All right.
Okay.
I'm going to make some corrections to the things I did earlier so they can get processed through. And then I guess the next, though, will be Bria Goodman. That one's correct. Lonnie Shannon. Oh, yes, there are court costs in there. I didn't, she said there weren't, but there are, so. Ms. Goodman,
Yes, sir.
All right, we've got, we'll go on the record then and cause numbers D37976, D38379, and D39150, All Style State versus Bria Nicole Goodman. I have counsel for the state and defense present. And Ms. Goodman, you're present. Is that your full and complete name?
Yes, sir, it is.
Ma'am, are you the same individual that was placed on community supervision by this court in all three of these cases?
Yes, I am.
In all three of these cases, the court ordered that you comply with terms and conditions of probation. And since that time, the state has filed motions to revoke probation. Is that correct?
Yes, it is.
And it's the court's understanding, ma'am, that you're wishing to enter pleas of true in all three of these cases to the allegations contained in the motions.
Yes.
And are you doing this freely and voluntarily, ma'am?
Yes.
Do you understand the consequences of pleading true?
Yes, I do.
All right. Mr. Keithley, do you wish to waive readings of all three motions?
Yes, sir.
Record can so reflect. Ms. Goodman, I have documents in all three of these cases that appear to have your signature on them. They are written waivers and stipulations on revocation and probation, a judicial confession, and a waiver of your right of appeal. Did you sign these documents in all three of these cases?
Yes, I did.
Did you have an opportunity to discuss these documents with your attorney?
Yes, we did.
And he went over them, is that correct?
Mm-hmm.
With you?
Yes.
You understand in all three of these cases, ma'am, you have a right to have contested hearings and you're waiving those rights.
Yes, I do.
Mr. Keithley is your attorney. Are you satisfied with his representation in all three of these cases?
Yes, I am.
Mr. Keithley, your client certainly at this point in time appears to be sane and mentally competent. Is there anything that your client has said or done that would cause you to believe otherwise?
No, sir. I believe she's sane and mentally competent.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered her pleas of true, that she understands the consequences of her pleas of true. The court will accept those pleas of true, take appropriate action based on the evidence. In both cases, I have states one, judicial confessions signed by the defendant, state seeking to have those exhibits admitted.
Yes, Your Honor.
No objection.
They're admitted. Anything further from either side?
No, Your Honor.
No, just Ms. Goodman has some considerable back time due to a stay and out of the Navarre County Jail and Ellis County Jail. I believe that time is correctly calculated on her judgment already. We just ask for all time credit off her sentences, please.
Okay. Well, I will take the recommendation then. If you want to start in the lowest cause number, we'll go from there.
Okay. Okay. In D37976, if I can calculate correctly, that's the lowest one. The state's offer is 18 months state jail with 432 days credit. All previous fines, court costs, and restitution. The fine was $1,500. The court cost was $274, and the restitution was $1,150.
How much credit?
According to Mr. Keithley, 432 days.
Okay. And Mr. Keithley, is that you and your client's understanding of the agreement in addition to the time credit?
With respect to that one, yes, sir.
Okay. I'll go ahead and go to the next one then, the next cause number.
D38379. The state's recommendation is also 18 months state jail, 386 days time credit, all previous fines, court costs. I don't show that there were any on the judgment, but there was a $1,500 fine on this one as well, and $180 restitution to DPS crime line.
Okay. And Mr. Keithley, is that your understanding?
Yes, sir.
And in D39150, this one is also 18 months state jail with 374 days credit for time served. And $180 restitution to DPS crime.
And Mr. Keith, is that you and your client's understanding on that?
Yes, sir.
All right, based on the evidence that's been admitted, the court will grant the state's motions to revoke probation and all cause numbers. It's the judgment of the court in each of these cases that Ms. Goodman is sentenced to 18 months in a state jail facility with any outstanding fines, court cost fees to be assessed minus, well, and any reason why sentence should not be pronounced.
No, no.
No, sir.
All right. Ms. Goodman, you are sentenced to 18 months in a state jail facility in all three of these cases. These sentences begin today, and you'll receive credit on any day thereafter you're awaiting transport to state jail. In 37976, ma'am, you'll receive credit for 432 days. And the other cause number 38379, you'll receive credit for 386 days. And then finally, in 39150, you'll receive credit for 374 days. You understand that?
Yes, sir.
All right, ma'am. Any reason why sentence should not be pronounced?
No, Your Honor.
All right, ma'am, you are sentenced to
Yes, sir.
18 months state jail facility. You'll be remanded to the custody of the sheriff, who will transport you to the appropriate facility, begin serving out these sentences. And again, I may have already said that, but I've sentenced you twice, but it's only one sentence you got to serve. The bailiff will come over and get some prints from you, ma'am, shortly on your judgments.
Uh-huh.
Do you have any other cases pending?
I have a misdemeanor case.
Okay. Ms. Goodman, where do you live when you're not, are you a resident of Navarre County?
I was before I got arrested, yes. I don't plan to be after I get out, though.
Okay. Well, ma'am, hopefully not. Yeah, do you have a substance abuse issue, ma'am?
Yeah.
Okay. I sure would like to see you try to figure something out as far as assistance when you get out, ma'am.
Okay, I have a question.
Okay.
What about all that money that's put on that? How am I gonna pay all that? I'm going to jail. I'm going to prison.
You'll just basically lay it out, okay?
Okay.
All right. Ma'am, again, I wish you all the best, and hopefully we can not see each other. And if you're not going to come back to Navarre County, I'm certainly not telling you not to, but wherever you go, ma'am, I wish you all the best, okay?
Thank you, sir.
All right, ma'am, in these three cases, you've waived your right of appeal. That concludes these three hearings. Good luck.
Maria.
Thank you.
Your Honor, I believe that does it for me. May I be excused?
Yes, have a good day.
Yes, sir. You too. Bye, Sherry.
Thanks for getting all those jail credits.
Yeah, it was,
Okay, the final jail person I have is Raphael Burrell.
We have him and Mr. Potter.
Oh, Mr. Potter?
Yes, he was
It's just
the,
a status.
Oh, yeah. Let's go up to the top. But let me get Mr. Burrell first. All right, this is cause number D39022-CR, State versus Raphael Burrell. I have counsel for both sides present, defendants present, and motion for experts. And I'm not sure whose it is.
It's the
I believe it's
state's
the state's
motion
motion.
for defense's experts.
Okay. You may proceed.
Your Honor, the state's just requesting that if there are going to be any experts in any phase of the trial, that those experts be disclosed to the state in the 20 days prior to any trial. I believe that I was informed that they wouldn't have experts for the trial itself, but maybe in the mitigation part of it. And we're just requesting that we know who that is.
Okay. Any response from the defense?
Yes, Your Honor. At this time, we don't have a trial setting, and I believe the rule requires us 20 days prior to the trial to disclose those. At this point, I don't believe we have a trial date. We haven't designated any experts. What the state is asking for is already what the rule requires in the 3914B. I think it only requires a request. I don't think there has to be a formal motion. So I guess we'll accept this as like the state's formal request for designation. But at this point, we haven't designated any experts and we don't have a trial date. So I don't believe the issue is right at this point until we actually have a trial date. But we do understand our requirements under 3914B.
Yeah, we'll have a trial date soon enough, and y'all will be the first to know.
Thank you.
All right.
Oh, I'm sorry, Judge. This whole time, I have Mr. Ichartea here, and he was supposed to translate for us. You don't mind if he just kind of translate what's kind of happened to Mr.
To your
Borrell?
client, yes, he may.
Buenos días, señor Borreal. Ahorita el Estado está pidiendo a la Fiscalía que si acaso su abogado tiene expertos, pues quieren que lo revelen. Dicen que ahorita no tienen por qué revelarlo porque hay un artículo en la ley que no lo especifica. En este momento no tenemos la fecha todavía para su juicio. So de esto se trata esta moción para el experto.
Okay. So, in short, Your Honor, we don't have objection to the state's motion. We don't think it requires a motion, just a request. But at this time, we don't have a trial date. So I don't know if there's a hard date set for what the 20 days prior to trial is. Since there's
I'll get a hard date, and as soon as you have that date, just go ahead and turn it over. I know the rules say 20, but you know, just so we're not stuck in a situation where on day 20, then you know the state's wanting it needed another expert. So
right,
I understand. All right. All right. Anything further?
No, no.
All right. That concludes this hearing. Thank y'all.
Ya concluye la audiencia, señor Borreal.
¿Perdón?
Ya concluyó la audiencia.
Ok. ¿Qué es el siguiente paso?
Le van a conseguir una fecha fija.
Ok, tengo una pregunta acerca de lo que decía de lo experto. ¿De qué se trata eso?
We'll come over and talk to him today in the gym.
Vamos a venir a hablar con usted personalmente, no lo queremos hacer sobre la computadora.
Ok.
Muchas gracias.
Gracias.
Ándele.
Mr. Potter. Romer, you've been turned over in a car accident?
Oh, do I look like that? I've got it like set up where my speedometer is. So I am on the straight and narrow though, headed your way, in fact.
Okay. Well, as long as don't need roadside assistance, we'll move on.
I appreciate your concern, but I'm good.
Okay.
I guess if I'm right side up, all of a sudden you'll know I was in an accident.
That's true. Everything's in reverse. Okay. Mr. Potter, is that you?
Yes, sir.
Okay. All right, we'll go on the record and cause number D36655-CR State versus Jonathan Potter. And I have counsel for both sides present, defendants present. This is status on a motion to revoke. Is that correct?
Yes, Your Honor.
Where are we on this case?
For me personally, so Sherry, did this go to somebody else and then come back to you? Is that the deal? Because I feel like I've talked to somebody else about this.
Well, it was Richards, but since he's retiring, it's now going to be Mr. Wolf.
Okay.
So the state right now is in a holding pattern because we're waiting on online solicitation of minor charges out of Ellis County to be levied against him. And so probably when Mr. Wolf gets here next week or the 1st of June, you may want to touch base with him.
Yes, and well, part of the issue is that, Judge, he has new cases that have been filed, and I believe they're in the other court. So he's got a fraud case that's in the other court, so it's kind of confusing. What we've been trying to figure out, and I think we addressed this in the last hearing, is what's going to happen in Ellis County, because I had initially received a probation rack on the new cases, but that was because that person didn't know that he had this pending revocation in Navarro County, because he also has a pending revocation in Ellis County. Okay. So at this point, I have not received a rec that will cover all of that, because the rec for the probation rec for the fraud cases was withdrawn, considering that there was the revocation, and they didn't know because I think they have his name misspelled or there's some kind of confusion about it.
Yeah.
And the case in Ellis County is a higher level offense, so realistically it's probably going to control kind of what happens here. I know myself, and I believe Sherry as well, has tried to reach out to Ellis County to see if either they can put a hold on him and so he can go over there, or they can tell us what they want to do to kind of guide what's happening here, and we've not received any responses.
So if we could just set it out in like 30 days, that'll give time, I think, for everybody to for Mr. Wolf to get here, for Ellis County to reach out, for Stara and them to all talk.
Would it help if Mr. Potter went to Ellis County?
I don't think at this time, Your Honor, that they've done anything. I think the charges have not been indicted.
They don't currently have a hold, Judge, because that was
correct. Oh. And I think that's what they're working on.
He's got a revocation.
He's got a motion to revoke based off of the new charges that they're going to indict him for, based off of all this other stuff too. So it's kind of a big pile. So I think if we could set it out for status and give Ellis County time to figure out what I think they're having their grand jury today, is what I was told by one of the other prosecutors. So we should have an idea in the next 30 days.
Okay.
Does he have additional new cases in Ellis County? Because no one has told me that.
He has, Mr. Reed, the prosecutor over there, told me that there's a pending online solicitation of minors. And that was all he told me. And I said, okay. He said there's a motion to revoke, and so we're kind of, that's why I'm saying maybe it's better if we just set it out a ways for you to talk to Mr. Reed and Mr. Wolf. I'm assuming you're on the Ellis County.
I'm not on the Ellis County cases, so I don't know anything about them.
Oh, okay.
And I looked and I don't see a court-appointed case. There's no court-appointed attorney out there, because I was like, well, maybe I can just reach the attorney. Because, Judge, I do agree with you. The most logical thing would be to try and get him to Ellis County, because that case is a higher level offense. But as I've said, and Sherry's mentioned, I've tried to reach out to Ellis County because they just need to put a hold on him, and then we could just PR bond him out of this county. But to date, they haven't put a hold on him, and my attempts to do that have been met with no response.
Mr. Wolf will be here unofficially on Monday. So, Ms. Romer, I will make sure to bring this to his attention and Mr. Thompson's attention to see if we can't move this along one way or the other.
Okay, so let's set it for status in 30 days, or give or take.
Thank you, Your Honor.
All right.
Okay.
That concludes this hearing.
Thank you, Judge.
Thank you.
Oh, and I am right side up, but I didn't die. Just
That's
here, I
good.
moved my phone.
That's good.
All right. Thank you.
Thank you. Be safe.
Judge, I think that's it for us.
Okay. It's not it for me,
Until
but
this
it's it for
afternoon.
you.
Yeah, I'll see you this afternoon.
I'll be here. Thank you.
All right. Have a good day.
You too. Mr. or Jessica Beard.
Yes, Your Honor. As of yesterday, Miss Beard was in the Travis County Jail on a new DWI charge.
Well, that's not
Yesterday?
That- It's not good for anybody.
No.
Did
I
we
like
just,
to-
did we just do a $10,000 bond on her with an ankle monitor?
Yeah, we just went through a whole rigmarole to get her out, and then I got a call from our from her Travis County attorney. I think she had got a court appointed, and he was asking me what we should do, and I said, "You got me."
Well, Your Honor, if we can go on the record, the state will ask for a bond forfeiture and a hold on her out of Travis County so we can get her here once she gets finished there, maybe?
Yeah, give me 1 second.
Okay.
So you're saying she's in Travis County?
Yes, as of yesterday, she was. Whether she bonded out since yesterday afternoon, I do not know.
The state would still like to for her bond.
Yeah, let me just look.
She is there, Judge. I've already pulled it up. She's
Okay.
Okay.
She was arrested, yes, on the 14th at 11:23 for a DWI Class B. Her bond set at $3,000.
Oh, she ought to make that.
Okay. Well, let's go on the record in D39505 State versus Jessica Michelle Beard. I have counsel for both sides present. Defendant is not present. Prior to going on the record, it's my understanding that she is currently housed in the Travis County Jail as of this morning. And so at this point,
The state would request bond forfeiture, NISI, hold on her, all bells and whistles.
I don't know if I can do a bond forfeiture based on the fact that she's in jail, but I'll certainly will place a capias and just place a no bond hold on her to get her back here.
Thank you, Your Honor.
So this was on a revocation of probation. Is that correct?
Yes.
Yes, Your Honor.
Deferred.
Yes.
All right. Yes, I'll make sure that hold gets in effect pronto so we can make sure she can come back here to this court without bond. So
thank you, Your Honor.
I guess that's all we can do today since she's not here.
All right. Thank you, Your Honor.
All right. That concludes this hearing.
Are we done for this morning?
Yes, ma'am.
All right. Then we will see you this afternoon, Your Honor. May I be excused?
Yes, ma'am. Have a good morning.
Thank you, you too.